really like to thank you, Christopher, for presenting for us tonight. Chris is a senior counsel and barrister based in the ACT from his background, and he's also been a mediator for a number of years. I think it was 2019, not long before COVID, and he joined officially as a mediator. But as we know, barristers have to do a fair bit of negotiating as well. Just before I hand over to you, Chris, I'd like to acknowledge Aboriginal and Torres Strait Islander peoples as the traditional custodians of Australia and pay my respects to elders past and present. And I'm coming to you from the lands of the Gunai Kurnai people in Gippsland. And you're in, what country is it in Canberra?
It's a bit controversial, actually, because they're on the border between three. Hence the name meeting place, which is the meaning of the word Canberra.
Absolutely. Thank you again. I'll hand over to you. And today our topic is around mediating litigation.
All right, thank you very much. I've been the barrister negotiating settlements in cases for a very long time. In fact, I think I might, as a barrister, have been in one of the very first mediations that ever took place in Canberra, which would have been nearly 30 years ago. And since then, I've become a mediator relatively recently. I've been doing quite a few mediations in Canberra. Mediation in litigation is very different from mediation that we learn. The frustrating thing is that in order to be a mediator for the courts, you not only have to be a lawyer admitted for 5 years as a practitioner, but you also have to go through the mediation training, even though the mediation training doesn't reflect how mediations happen in court cases. I thought it would be useful to have a short presentation about the key differences between the mediation that we all get trained in and the mediation that takes place in relation to litigation. I make the point here that mediations are now being routinely ordered in civil cases in courts and tribunals right across Australia. And if we go to the next slide. Now, I need to put this disclaimer in because everything to do with family disputes, so that's it used to be called the family court. There is a specialized and very important form of mediation that happens in that court system and in associated tribunals around Australia. And I'm not dealing with that at all. So nothing I talk about tonight is going to have anything to do with that kind of mediation. Not only is mediation being ordered by courts, but the parties in litigation, not uncommonly, sometimes try and have a mediation of their own. They hire a private mediator and they have a go at trying to resolve their dispute. What it all amounts to is that mediation is now routine in pretty well all litigation. Most courts and tribunals have panels of accredited mediators who are assigned to do mediations at the court's order. I'm on a panel of mediators for both the ACT Supreme Court and the ACT Magistrates Court. Between those two courts, we do over 100 mediations a year, and we are the smallest court by far in Australia. So if the ACT is doing 100 or so, I think you could say that across Australia, we're dealing with thousands of mediations happening in litigation. So there's quite a lot of it going on. On top of having panels of mediators, some courts, if we go to the next slide, also have mediation suites. The ACT courthouse, for example, was completely reconstructed about 10 years ago, and it has the most fantastic set of mediation rooms. We've got 4 of them, I think, in which you can bring everybody together, and there are like 20 breakout rooms, and we've got audio-visual facilities and all sorts of things. So it's a big thing. The courts are taking mediation very seriously, and they are putting in the facilities to make sure it can happen as easily as possible. So what this means is that mediation is a practically universal step in preparing a civil case for trial. Most of the time, they are directed to happen once the case is prepared and the hearing date is about to be set. That's particularly the case in courts, and I'll explain more about that in a minute. There are some exceptions, notably in the civil tribunals around Australia. So that's ACAT, which is the ACT Civil and Administrative Tribunal, NCAT, which is the New South Wales Civil and Administrative Tribunal, and you get the idea. We've got VCAT, QCAT, so forth. Those tribunals often order mediation a few weeks after a case has been first listed. By the time you get to a mediation, you will have the government documents if it's a challenge to an administrative decision, but you won't actually have witness statements necessarily at that point. But so there's still various documents around which tell you something about the case. The main differences between the mediation we're trained to do and the mediation that happens in litigation is the dispute is very well explained and documented before the mediation begins. And I'm going to give you some illustrations of the sort of stuff we have before you even meet the parties. The second difference is that, particularly in the courts, less so in the tribunals, the parties are usually represented by experienced lawyers, and I'll explain a bit about that. And the third main difference is that if the mediation fails to resolve the dispute, it's going to go to a hearing. So there is quite a different dynamic because this is a step, but it's not the only way in which the matter might get resolved. So we have to view the mediation as taking part in the context of a dispute that at some point or other, if it doesn't settle, is going to end up before a judge. There is a further difference, which I didn't put in the slide, but particularly with the courts, judges have the idea that mediators should be offering advice to the parties about the strength of their case. I have real difficulties with that. As recently as February this year, for example, the Chief Justice of the ACT Supreme Court sent out a nice little message to welcome the start of the year. And she was talking about mediations, and she mentioned that, we've got all these wonderful mediators, and they might at some stage give you some gentle advice about your case. I read this and thought, I've got difficulties with that. So let's move on. First thing is, what documents do you get? Well, if you're running a case in court, you're going to get what we call the pleadings. And I don't know whether any of my viewers are lawyers or not, but pleadings are the document which begins your case. In the pleading, you have to set out, as the person who's claiming something, the key facts. The second thing you have to show is how those key facts establish a legal right or a claim. And the third thing you have to say is, what outcome do you want? Now, the outcome may well be damages, that is money. Sometimes the outcome might be an injunction, which is to stop someone doing something. But you have to set out what it is that you want if you were to win the case. This is true of all civil courts and all tribunals. Litigation is also run with evidence from important witnesses. Many cases are run using written affidavits or witness statements provided in advance. What that means is that the people who are going to give evidence may well have set out in a written document, and if it's an affidavit, they have sworn that it's true, like a statutory declaration, what they saw, what they heard, what their evidence will be, particularly when you're getting things like personal injuries claims or claims about defective machinery. You're going to have expert reports. Experts are people like doctors, expert engineers, town planners, people like that who've got a special expertise, and they're going to give you opinions about key issues in the case. For example, if it's a personal injuries claim, you'll have the treating doctors giving you reports about what treatment the plaintiff has had, what the outlook is, what treatments might be available down the track to improve their condition, and so on. And you not only get those from the claimant, but if you are running a personal injuries case, the plaintiff will have gone to see doctors hired by the defendants because the defendant wants their own expert doctors to have a look at the person to see what they think is going on. So you're going to have quite a lot of things like medical reports. If you're doing a planning case, you're going to have town planners in all directions giving you their opinions about how the planning system might work. So you're going to have a lot of expert evidence reports in this sort of situation. And if it's in writing, it's available in advance for most mediations. Now, as I mentioned a few minutes ago, the exception is administrative tribunals like ACAT and NCAT. If a mediation's been ordered early in that process, you won't have had the witness statements because the tribunals sometimes head things off to mediation at an early stage to try to avoid the need for people to have to put together all these witness statements and go to a hearing. But even there, even in an administrative tribunal, for example, before it goes to the mediator, the government side will have to have produced their file to the tribunal and copies given to everybody. So you will have the whole government department file that relates to this matter, which you can pore over. So you're still going to have quite a lot of information before the mediation even begins and before you've even met the parties to the mediation. I want to show you the level of detail that we're going to get in the pleadings in particular. And I'll give you an example of a plaintiff claiming damages for injuries in a car accident. There are a number of things that the claim document, that's the pleading, has to set out. So the first thing it has to set out is the key facts. And so I give you an example here that it will tell you that the plaintiff was travelling in a car which had a particular registration number on such and such a date on such and such a street at such and such a time. At the same time, the defendant was travelling in a truck and you get the registration detail on the same street. You'll then have a claim that the defendant's truck suddenly veered into the oncoming lane, hitting the plaintiff's car head on, causing substantial damage. Now you have all the key facts set out as to what happened with this accident. The claim document then goes on, having set out those key facts, to establish a legal basis for the claim. So you not only get the facts, but you also get how those facts lead to a legal conclusion. I give an example here of the plaintiff travelling in a particular lane, the defendant suddenly veering. The defendant's action was therefore in breach of a regulation of the motor traffic regulations. The defendant's driving was negligent. So you've now understood that the claim that the plaintiff brings is because the road rules weren't followed and the defendant was negligent in the way in which they were driving. And then the next thing that the claim document does is to set out the consequences of the accident. And so in this example, the plaintiff was injured and the car was damaged, but we go into much more detail because you have to give particulars. So you have to say what injury the plaintiff got in this accident, in this case, a broken left arm, bruising, nervous shock. There are particulars of damage to the car. You describe the amount of damage that happened and what had to be done to fix it. As a result of the injuries, the plaintiffs incurred medical expenses. And these are set out in great detail, including Medicare rebates. There may be a claim that because of the injury, the plaintiff had to take a number of weeks off work and therefore lost wages. So then you have to set out on a schedule how much has been lost in wages. Next slide. So that's what the plaintiff does. And then the defendant has to put in a document called the defense, follows the same pattern and tells you the defense's position on each of the elements in the plaintiff's document. In this hypothetical example, the defendant might admit that they were travelling in that truck on that street on that date. That means that we can now take it as agreed that on that date, on that street, the plaintiff was driving the particular car, the defendant was driving the truck. The defendant might deny driving negligently and deny suddenly veering onto the opposite side of the road. So then there's going to be a contest about whether the plaintiff's got a right to bring a claim at all. In this hypothetical, the defendant might say that from the defendant's perspective, it was the plaintiff who moved across the centre line of the road and made the collision unavoidable. And then in this hypothetical, the defendant might admit that the plaintiff was injured, but says that they weren't all that severe and the plaintiff should have been able to return to work within 3 days of the accident. Next slide. In this hypothetical, you've digested quite a lot in a short space of time. But what it means is that before the mediation begins and before the mediator even meets the people involved, the mediator is going to know the facts about the accident, the competing claims about how it happened, the consequences of the accident, including what's clearly an argument about the extent of the time off work, and the full extent of what has been claimed by the plaintiff and why it has been claimed. In other words, before you even meet the parties, the mediator knows all the stuff that we are being trained in mediation training to have to extract out of the parties in their own words. Not only do we know it as mediators, but the parties know it too, because everything I've just described is shared between the parties. The plaintiff's claim document, for example, is given to the defendant. The defendant's defense document is given to the plaintiff. If there are expert medical reports, they are shared with the parties, so on. That means that actually everybody in the mediation room, before the mediation begins, pretty well knows what the case is about and what the extent is of what's claimed and why it's being claimed. If we assume that the mediation has been ordered by the court once the case has been prepared, you will also have on the file the witness statements, which have been shared. You'll also have the expert medical reports, which have been shared. And you'll also have schedules of medical expenses and lost wages, which have been shared. It's normal and expected for each party to provide what's called a position paper, which you share between the parties and the mediator. And the position paper summarizes what the case is about. It provides a summary argument that sometimes fleshes out things that might be a bit terse in the claim document. It tells you the response to arguments raised by the other parties. And if there have been any updates, for example, recent medical treatments or update on lost wages, it will set that out as well. So just to sort of ram the point home, if you haven't worked it out by now, before the mediation begins, this is what the mediator and the parties all know before they've met each other. The last point I say there is some idea of the strength and weakness of each party's position. That will often become apparent on the documents because when you look at them, you'll see that perhaps one part of the plaintiff's claim is a bit of a speculation. Part of the defence might look a bit flimsy, so maybe that isn't going to be as strong an issue for the defence as you might have thought. So you actually have not only all the information, but you often are getting a feel for which are the strong bits and which are the weak bits for each side in the dispute. This brings us to the second big difference. Now, there's no obligation in a court case for you to be represented by a lawyer, and we do sometimes have, even in the highest courts, litigants turning up in person without lawyers to represent them. But I think I'd go as high as saying that something like 99% of civil cases in the higher courts and a sizable proportion in the lower courts have lawyers. And the lawyers you get depend to some extent on the scale of the case, but you may well have an experienced solicitor who's been running the case for a particular party. A solicitor who's acting for a party will have had extensive conferences with that party they represent. They'll have sat them down and interviewed them for a long time about what happened and what they're looking for and what their problems are. The solicitor will also have interviewed witnesses. The solicitor will have drafted the pleadings. They'll have organised the expert reports. They'll have helped draft the affidavits or witness statements if required by the court. In other words, the solicitor is going to know a lot about this case, probably more than the plaintiff. Next slide. In bigger cases, you'll have more than one solicitor for a party. I did a mediation at the end of last year in a relatively small personal injuries case, but the insurer turned up with the senior solicitor, a junior solicitor, and a paralegal, together with the claims officer from the insurance company. So you may actually end up with a team of lawyers filling out the mediation room on one side. Next slide. In many cases, you will also have a barrister and occasionally two of them for each party who have been briefed to run the case in court. The barrister in particular will have been looking at the case from the viewpoint of how to present it to a judge. So the barrister will have been thinking about how to present the case, how to cross-examine witnesses, how to assess the issues they need to explore in the evidence, the sort of submissions they're going to make to the judge, and so on. They are looking at the case from the particular point of view of presenting it to the judge. And they're going to have a pretty good handle on how the case is likely to unfold in the court. This brings about a huge difference in the dynamic in the mediation, because it is the lawyers who will usually do the talking. Indeed, in many cases, the lawyers will want to avoid having their own client say anything at all, because the client can sometimes not understand some of the issues that are involved. So the mediation in litigation, you may not hear a word out of the plaintiff other than introducing themselves at the beginning of the mediation. And all the talk will be done by the lawyers. And as you've already got the idea, the lawyers will be across the claim, they've got across the detail, they'll understand the disagreements, they'll know the legal principles, and perhaps most importantly, is the bit I put in italics, they'll have been retained to be an advocate, because that's what they do, that's their job. So they will be particularly there because they're good at doing the talking and explaining the case to other lawyers. Next slide. I should note that once in a while, a mediator has to be alive to the possibility that the lawyers are actually getting in the way of a settlement. Lawyers can be less inclined to resolve things. Most lawyers want to settle it because they can see the weaknesses, but some lawyers get seduced by what you see in Hollywood movies and think that the best way to fight a case is to fight every single issue and get in the way. And if you see this happening as a mediator, you have to think about kicking the lawyers out and talking with the clients. However, the flip side to that is that as a mediator, you have to be very careful not to interfere. The client has retained the lawyer for a reason. They're paying the lawyer money in most cases. And the relationship between the lawyer and the client is an extremely important one. And as a mediator, you really have to be very careful not to undermine that or suggest that the lawyer might be a problem or advise the client to get a new lawyer. So it's a very delicate situation to be in if you think the lawyers are getting in the way. Next slide. This brings us to the third major difference, which is that you're dealing with a dispute where the resolution is going to happen one way or the other. It's not as in the sort of mediations we're trained to do, where if you don't settle it during the mediation, it's not clear where the dispute's going to go. We know exactly where the dispute's going to go, and we know exactly who's going to resolve it. And this means that when you're dealing with mediation in litigation, you're dealing with parties who have already decided that they're going to have their day in court. It's not going to be, their claim's not going to be abandoned if the mediation doesn't solve it. That's where it is heading. Second, the next slide. You're dealing with a case where the case has already been very well prepared. So we're not going to have very many loose ends or uncertainties at this point in the process. We've got a pretty good idea, not only where it's going to get resolved, but the sort of material is going to go to the court to hear it. And the third difference, if the mediation doesn't succeed, it's going to trial and it will be resolved. So if we go to the next slide, what this leads to is that you have a very different dynamic for a litigation mediation from what we are trained to do. Speaking as someone who was involved in dozens, if not hundreds of mediations before I did my training, the training was a real shock, because the training was to tell us what we have to learn, and the people who are doing the training through the mediation organizations doesn't bear much relationship to the mediation going on in courts. I should add here that the skills you learn through that are actually quite useful, because it is often quite useful to be able to use some of those skills if you're having a chat with the client on their own. So it's not useless, but the point that I'm making is that a lot of the things that the mediation training assumes don't happen in litigation. That is, you're going to have to tease out all the information. In litigation, we know it. And so it would be helpful, I think, in due course if we had a branch of mediation training which actually dealt with mediation and litigation and helped to explore some of these differences. And the point I make at the bottom of this last slide is, if you're a party and you're going into a mediation and you know that next month, if we don't settle it today, it's going to go to court, all of a sudden the court process becomes very real. Nothing so focuses the mind as the realization you're going to get cross-examined next month if you don't solve it now. So it actually sometimes produces a dynamic with the parties that they would actually like to settle it so they don't have to go to court. It's one thing to go to your solicitor and be told that your case might get heard sometime next year. It's another thing altogether to go to your solicitor and be told it's going to be heard next month. If we go to the next slide, there's another complication that arises not infrequently, or put it another way, quite often, which is that you might have more than one party. For example, let's take a workplace injury. The plaintiff sues the employer. The employer defends by saying, it wasn't my fault that the plaintiff got injured. It was the equipment they were using because it was defective. So I'm going to sue the manufacturer of the equipment because the equipment didn't work properly. Now you've got three parties in the case. The plaintiff saying I was injured, the employer who was employing the person should have had a safe system of work, and the employer has added on the manufacturer of equipment saying it was actually the defective machinery. Another example is in a car accident, but the plaintiff might have had injuries from a different accident some years earlier. And there might well be a medical issue about whether the extent of the injuries that the plaintiff now has were caused by the first accident or the second. If the two accidents had different insurance companies, then you're going to have two different insurers turning up on the defense side to defend the claim. There are plenty of other illustrations of how you can have more than one defendant in a case, and they add an enormous complication to trying to resolve a matter. So we go to the next slide. Where you've got this situation arising, you often have to have a mediation inside the mediation between the defendants, because if you think about three or more parties, you've got the plaintiff saying, I was injured, I want some money, and you've got a number of defendants who might be prepared to put some money in to help settle the matter. But in between them, you may well have to conduct negotiations as to which of the defendants is going to contribute more or less. If you've got three defendants, it may double the length of time that it takes to conduct the mediation, because the first thing you've got to spend hours doing is getting the defendants to agree on the sort of offers that can be made to the plaintiff to try to resolve it. Sometimes the defendants might take a different position. One insurer might say, I'm prepared to go as high as $50,000. And the other insurer might say, well, I'm prepared to go as much as 25% of the eventual amount of money. Trying to square those two positions is not easy either. Another complication is that on the defense side, you may have a situation where the person who's turning up from the insurance company or the government agency might not have authority to settle it, or might only have authority up to a certain amount of money. That defendants have to turn up with full authority to settle it. But most insurance companies still don't do that. There might be some senior person in the insurance company available on the phone in Sydney, but that's not very helpful if that person is not sitting in the mediation listening to what's going on. And so if you're confronted with a situation where the defense side mightn't have full authority to settle it, what do you do? Do you postpone the mediation even though everybody's there and ready to have a go? Do you go on and hope that somehow we'll sort out authority to settle? It's not a comfortable position to be in. So let's move to the next slide. How a mediation plays out in litigation depends to some extent on individual mediators, but as the general rule, because most of the essential information is already known, the opening session is brief and sometimes it doesn't even happen at all. I would think probably a quarter, perhaps a third of mediations, you don't even have an opening session except to introduce everybody, because everybody knows what the dispute is, particularly if you've got barristers involved. They've already given advice to their client about what the strengths and weaknesses are. If you were to have an opening session explaining what your case was about, you're simply repeating what everybody knows. Occasionally, it's useful to have somebody explain something particularly personal. For example, if somebody has been traumatized by an incident, it might be a good idea to have them explain briefly how this has affected them, because you can see it written down on paper, but saying it in person is often more powerful. A lot of mediations don't even have an opening session. Where the case is going to resolve with the payment of money, that is damages, you need to get an agreement between the parties as to how we're going to exchange offers, particularly where legal costs are involved. So are we going to say there's $20,000 for the plaintiff plus costs? Or is it going to be $30,000 to the plaintiff, including their legal expenses? If you're going to be exchanging offers, you need to be exchanging them on the same basis. So you need to sort that out at an early stage. Next slide. There's a few situations where having everybody together in the room at the start of a litigation mediation is an extremely bad idea. The most unpleasant example is sexual assault cases, particularly historic sexual abuse, where the plaintiff cannot bear being in the same room as the representatives from the church or the scout group or whoever it might be, who the plaintiff says were responsible for what happened to them. Where I've got a mediation, before I meet everybody, I ask the plaintiff's lawyers if they want the plaintiff in the same room as the defendants or not, before we even begin. I then know whether we should be skipping the opening bit with everybody getting to meet each other. There was one mediation I did a couple of years ago where the plaintiff was very distressed to be in the same room as the defendant. The defendant, which was a religious order, Catholic religious order, the person who turned up was actually the head of the order from Sydney, a remarkable man. He felt acutely the pain that had been caused by all of the claims made against some of the people in many years past. And he gave a sincere and fulsome apology to the plaintiff, which actually made quite a difference to being able to proceed with resolving it. So just occasionally, even in these very difficult types of mediations, just occasionally, a very personal touch like that can sometimes make a difference. You just have to judge it all terribly carefully. All right, next slide. Let's be honest, most cases in court are resolved with money, and I've already mentioned you need to have agreement on the basis. But if money is not the only issue, is something else going to be needed to solve the matter? Particularly in a workplace dispute where somebody's been unfairly dismissed, maybe an apology or an acknowledgement of harm caused by senior management might be useful in trying to promote resolution of the matter. It's sometimes worth exploring whether something other than money might be worth discussing as a solution. But to be honest, 95% of the cases are going to be resolved on the basis of how much money is passing from the defendant to the plaintiff. Next slide. Bearing in mind that the mediations are happening in the context of litigation that is looming, you've been given a hearing date, even if you can't resolve the dispute completely, you might be able to settle part of it. If you've got multiple defendants, you might be able to at least reach an agreement that gets one of the defendants out of it. If there's an issue that can be agreed between the parties, you might be able to that, which will shorten the hearing because several witnesses won't have to be called. So there are still things that you might be able to do as a mediator to at least make some use of the time that you've had with everybody in the same room trying to resolve the matter. And then the last slide for now is where you have reached an agreement, it is absolutely essential that you put it in writing immediately before everybody leaves. Experienced solicitors will turn up with a laptop with a boilerplate precedent for document that sets out the terms of the agreement, which will be exchanged before everybody leaves. Indeed, some solicitors turn up even with a little printer, one of those little portable printers, so they can print it out and people can sign it. If you haven't got the printer, you can write it out by hand. It is really incredibly important, if you've got a resolution, write it down, sign it, get everybody signed up to it, because there is a well-known condition that parties go away from mediation having resolved it, and they wake up the next night thinking, oh my God, I shouldn't have done that. I should have kept going with the case. And really, that's just misguided on their part. It's always better to solve or to resolve litigation, but you need to rule out the possibility that they're going to come back and try and undo the settlement. Sometimes extra terms will have to be sorted out down the track, but you can agree on the basics for the rest to be set out in a later deed. And that's not uncommon, where you've got things like you're still waiting on the final payout that has to be given to, say, Medicare if there's medical expenses to be paid back, things of that kind. But you can at least get the nuts and bolts of the agreement sorted out on the day. Now, that's the last slide, but I wanted to make a couple of comments about the extra point, which is that there is an expectation from a lot of judges that mediators, all of whom have to be experienced lawyers, in an appropriate case, should be giving what the Chief Justice called gentle advice. There's a lot of difficulties with that approach, I have to say, which I don't think the judges realise. First is the mediator might know an awful lot of information, but they know nothing like as much information as the parties have. So I might get all the documents, say, for a personal injuries case, but I am seriously not going to read 500 pages of medical reports and doctor's notes in order to get all the details of what the plaintiff's injuries are. There may be all kinds of things up the sleeve that a party has to cross-examine key witnesses, which they're not going to give away in the course of a mediation with the other side being present. If the case goes to a hearing, it's possible that a party has all kinds of damage that they can inflict on key witnesses through cross-examination. The witness might have said something completely different in another document. So there's all sorts of reasons why a mediator, while they might know a lot about the claim, isn't going to know the full details. So I have real difficulties with the idea that part of our job is to give advice. And yet I hear particularly mediators who used to be judges, and there are quite a few of those. Some of them are renowned in anecdotes that you hear from other practitioners for browbeating people in mediations. So they hear what the parties have to say and then get stuck into one side saying, that claim isn't going to work. You know it's not going to work. You really need to get more serious about settling this, and really getting quite aggressive in the mediation process. I think that's wildly inappropriate. There is this unfortunate expectation from a lot of judges that mediators are kind of deputy judges who should be giving hints to parties that they need to consider just how weak parts of their case are. And it's something we have to deal with. That's what I think are the key differences between the mediation training that we get as junior mediators, which is required for mediators in litigation, and what actually happens when you get to mediate a court case. So having said all of that, do we have any questions?
There have been a few as they've been going through, Chris. Thank you. It's been very helpful. And I tend to think of it as almost a settlement conferencing style of mediation.
Yes, it is. Indeed, I should add on that very point. Sometimes if I've got two very experienced barristers on either side, and there's a personal injuries case where everybody knows the range of damages, as a mediator, I've got to be careful not to get in the way, because the two barristers are going to take the lead in trying to settle it. It's not at all unknown that before the mediation begins, the two barristers have already been talking. We might actually be well on the way to negotiating the outcome before the mediation even begins. You have to be careful not only to make sure that there aren't impediments to mediation, but you need to make sure that you as the mediator aren't getting in the way.
Absolutely. There are a couple of questions now. Nalika, you were paying great attention as you were going through. You can take off mute if you like to ask directly. One of the questions early on was around those court lists. How does that happen? How do people get referred matters through those court lists?
I can only speak for how it happens in the ACT courts, but I believe that the way we do it is not dissimilar to how it happens in the major Supreme Courts. In our two civil courts, the court allocates a listing for a week. So I might get appointed as, well, for example, in October, I have a week as a mediator in the magistrates court. And for that week, I could have up to 10 cases to mediate. So I'll have one in the morning, one in the afternoon, 5 days a week. That means that I will have 10 sets of files that I have to get across. I'll start a mediation at 9:30 in the morning. If we're still going at lunchtime, I have to park them in another room because I've got another mediation starting at 2. The court, when it is listing a matter for hearing, it will say, okay, I'll give you a hearing date on the 27th of April, and I'm listing it for mediation in the week starting the 3rd of March. So when you are getting a hearing date, you will also be getting a mediation date.
Yes. You shared with us all of the materials you get. You couldn't possibly read through all of those, and you alluded to that a bit as well. So I'm just wondering.
It depends on the case and how much you get. If, for example, you're in the Supreme Court or the Magistrates Court, a lot of your cases are going to be medical cases. So they're going to be personal injuries or medical negligence or workplace injuries, that sort of thing. There's going to be a lot of medical reports. A lot of it's not going to be terribly relevant. You know, if you've got a plaintiff where the accident happened 5 years ago, for example, you may well have medical records in the file, but the medical records will be that on this date they went in because they were suffering from the flu. And on another date, they went in to get their COVID shot because it's their GP. A lot of the material that you're going to see is just entirely irrelevant. You really don't have the time to sit down and go through all of that because you're not going to hear the case. On the other hand, you will get expert medical reports. So you'll have Dr. So-and-so saying that on this date, plaintiff presented to my rooms and I asked them these questions and I did these tests and I looked at the documents and my opinion is X, and it's all set out in full medical jargon, so you've got to learn all the medical terms for these things. They can sometimes be useful, but at the end of the day, if the plaintiff's doctor says this person will never work again, and the defendant's doctor says, of course they can, there's a big difference between those two positions, and exactly how the defendant's doctor came to the view they did as opposed to the plaintiff's doctor is going to depend on a huge amount of stuff which the mediator doesn't know. What records did they have? What things did they take into account? That's all going to have to get teased out when the two doctors give their evidence to the judge. So there's a lot of difficulties with giving advice in those circumstances because you just don't know all the information.
Yeah, no, absolutely. There does seem to be a lot of confusion there, and Jodie's alluded to it, that often lawyers are wanting mediators to give advice in those contexts. Why don't you do arbitration? In that case, you can get your private judge and they'll do a ruling and go through.
Well, mediations are part of what's called alternative dispute resolution. And there is actually another thing which is not very often done, where the parties can agree to put the file to a retired judge, for example, who will go through the file and give their opinion. The opinion will come with all the usual caveats. They can only go on what's on the paper record, and they're not going to call witnesses or anything of that kind. But it would be helpful to the parties to get somebody else to cast an eye over how the claim is looking. There is a quite different process available as an alternative dispute resolution if that's what the parties want. Mediation is a different exercise in which you are trying to encourage the parties to negotiate an outcome. So the very first mediation I was ever involved in as acting for a party was before the former New South Wales Chief Justice, Sir Lawrence Street. And he more or less introduced mediation to litigation in Australia. And he was fond of saying the best outcome is the one where both parties walk out of the room unhappy, because it means that both parties will have given up quite a lot in order to resolve the dispute.
Yeah, it's an interesting perspective. Big fan on compromise, I think.
Yeah.
And there was some questions around that, let's strike the deal while it's hot and get it locked in, as opposed to having a cooling off period or having time to reflect. And I think that's a factor of the context you're talking about for this type of mediation.
There was a really fraught mediation I was involved in for a party many years ago, and it was spread over several days. The stress of negotiating was so bad for one of the parties, they had a bit of a breakdown. So occasionally you have to have a bit of a cooling off period. Everybody goes away and comes back tomorrow because one party simply can't cope. But that's pretty unusual.
Look, there's still a lot of the ethical and other underpinnings from the AMDRAS that still apply, and balance of power and that sort of thing. So usually you've got advocates on both sides. I suppose it's a little bit more risky or difficult with self-represented litigants. Often they've had lawyers and sacked a few. I imagine you've had some of those cases.
And with particularly obsessed self-represented parties, they will sometimes put forward a claim that simply isn't open. They might be in the wrong court, or it might be that they think the law says such and it doesn't. So there are occasionally situations where with a self-represented party, you might have to say to them, look, I don't know the strengths and weaknesses of your case, but you can't bring this claim in this court because it doesn't have jurisdiction. Occasionally there are obvious situations like that, but 99 cases out of 100, the case is proceeding through the court because the court does have jurisdiction, and at least in principle, the court could decide in favour of the plaintiff. I think lawyers asking the mediator to give them advice is a little bit misguided.
Yeah, absolutely. Quite a lot can be achieved with some good reality testing and questions, I think. Now, I'm mindful of time. We could easily keep going for quite a while. Are there any final questions, Joe? You look like you...
I was just wondering I don't know if this is a type of mediation then, when you're, but anyway, if they're trying to work out between the barristers and so on, and you have to kind of tell them that you can't actually give advice because you're not allowed to, so you're not allowed to give suggestions to other people. Don't you just isn't it normally done in private sessions and you actually try to put them to think about the other person's position and actually think about that way?
Yeah, you can do that.
Yeah.
But bear in mind too that many of the big cases, say the personal injuries cases, on the other side, you're dealing with an insurance company.
Yeah.
And the person from the insurance company has on their desk 150 files. And there are 150 individual people who have been injured, who have lost money, who are hurting, who have a terrible situation to explain. And I don't mean to be rude to insurance assessors because they have to look at it commercially, but it's not going to get you anywhere if you do that.
And they might have a bonus depending on keeping their claims down.
But even putting that to one side, there are some people who that's going to cut very little ice with.
Yeah.
And
but it's not just that. Don't you need to also remind them if it doesn't get decided within the mediation, what their position, if it goes to court, if it goes to trial.
Oh, absolutely.
The judge going to do. And if it's going to go to that, it's best to try and work it out here. You know what I mean? If they already know
the one piece of advice that you can give, and it goes to both sides and it means exactly the same to both of them, is that any experienced lawyer will tell you there is no such thing as an unlosable case. I have lost cases I should have won. I have won cases I should have lost. And it's all because you've got a human being sitting on the bench who is going to try and resolve the matter. And they don't always see the case in quite the same way as the parties do or you do. If you can negotiate a settlement without having to go to a judge, not only do you regain control over the outcome, but also you're going to avoid all the stress that's coming up of giving evidence, of being cross-examined, of sitting there waiting to see whether the judge is going to find in your favor or not. So yes, I have a spiel at the start of every mediation that I do like this about the fact that for the parties to agree on an outcome is infinitely better than going to court, and that they should try as much as they can to negotiate an outcome. I don't call that giving advice. I just call that telling them the facts of life.
It's quite different to saying specifically, no, your case is useless, you're going to lose. That would be inappropriate. But as you said right in the beginning, sometimes like maybe 3/4 of the cost of going to the court is already sunk cost. And sometimes people think, oh, well, I may as well get my money's worth on all that prep. Thank you so much, Chris. That was really beneficial and something we'll share with our students so our lawyers won't be so frustrated to think we don't understand there's a broader context than facilitative mediation. Thank you.
All right.
Okay, thanks for that. Have a good evening.